Hey, everybody. Welcome to the Illegal Moves podcast. I'm
Well,
Liz.
and I'm Taylor, where we're covering sports from the field to the court. I'm sorry, I'm so excited.
I fucked up the opening. I think I fucked it up. But
No,
we
no,
are
no.
excited.
I am excited. This is what I've been wanting to talk about, but
But wait, but
we're
wait.
gonna small talk anyway and make it. Well, I guess they're gonna see the episode title name.
I know. But
Uh,
how's your week been? We're a couple days late on recording this podcast because I have
oh
been
God.
so
Yeah. Okay.
so popular this week.
Yeah. So tell everyone, all the viewers at home, listeners at home, what you got to do this week up in our nation's capital.
Well, I traveled all the way from my house on the metro to downtown DC, where I am part of a fellowship of influencers who were selected by the German Council on Foreign Affairs. It is the German American Influencer Initiative, and I was one of the US influencers who was identified as being very strong in mobilizing and fighting disinformation and misinformation. So we had our conference here in DC, and then our part two of the fellowship will be in Berlin, Germany
Ooh. So
this
this
spring.
is like the German government. I mean, this is like a
Yes.
thing from them, right?
Yes.
That's cool. Well,
Yeah. In
in
partnership with the US government, because we did things like we toured the Capitol, we met
right,
with a
right.
staffer from the House Foreign Affairs Committee. We had all kinds of experts come on panels to talk
Yeah,
to us about
and
all kinds of cool
you had a
things.
great time at the Capitol. A lot of history in that building. A lot of history there.
Yep.
Well, in equally, I would say, exciting news. All my fellow fantasy footballers out there know this is week one of the playoffs, and I did make the playoffs as the second seed, just a 14 playoff in my league. I put up 180 points this week. I'm done. My players are done. No one tonight. No one tomorrow. Um,
Okay.
Absolutely stomped this guy. I'm feeling good. I'm definitely going to make it to the championship and looking to bring it home. Bring it home. It's been a rough couple of years. Haven't won in a couple of years, so it's time. So yeah, equally exciting stuff. I think that we're doing.
I think very equal, very equally
Yeah,
exciting.
yeah, absolutely.
And you went to Zoo Lights.
I did. I went to the thing where they put Christmas lights on the zoo stuff.
Yep.
Um, it was fun. I did enjoy it. It's great birth control. For me personally, it's a lot. It's a lot, and it's but hey, I get it. It's tough. You get to ride the carousel once. You can only ride it once though. You got to go because there's other kids in line, and that's tough. You just want to stay on the carousel. I understand why that can be upsetting. For some, but
Am I taking it that you guys had a traumatic moment on the
a
carousel?
little,
Fun
a little bit.
Fun
But
fact for our viewers, Taylor's partner, aka my best friend Catherine, is my child's godmother, but Taylor is not his godfather. So if my husband and I both kick the bucket, God forbid, knock on wood, I don't know what Taylor's going to do.
no, here's my thing. Here's my thing that I like. I personally don't want kids. However, uh, you know, my friends' kids, um, your kid, her sister's kids, like I will do anything for them. Absolutely, whatever they need, that's
Oh,
fine. Like I will go to war for those kids. Like
I
I
hear
you
that.
know now everyone else's kids, I don't. I'm not, whatever. You got them, right? You're fine. Those parents got. I'm good. I don't. You don't need me. You don't need my help. But yeah, my little circle, right? My little people. I take care. I'll take care of their little people.
He's got it. He's
So
got it. Just another. I know we're like doing a lot of small talk here, but I feel like this is relevant. Uh, Taylor and Catherine have four cats, and we have two cats.
hmm
And
hmm
my cat Meredith Grey is the sibling of two of their cats,
yeah.
Ambrose and Taco.
hmm
And Meredith is very vocal. And Taylor, you will be coming to visit us next month. And I don't know if you know this, but there are times throughout the day where my son and Meredith meow at each other loudly, back
Oh,
and forth.
Okay. Well,
Meredith
yeah,
has
that's
trained the child,
that's
so
good. That's good.
to be a
Well,
third
yeah.
cat. He
Well,
is my child
luckily,
is a third cat now.
good. Well, luckily, we'll stay in a hotel, so I don't have to listen to that all day long. No, it's gonna be fun.
I
I look
highly
forward to that,
recommend it.
and I don't know what exactly we'll record up there. Or do we're definitely going to record an episode. I also
Yes.
I think we should pop around the town, and we can I don't know, find some interesting
We
stuff to
should
talk
do
about.
we should go to the various we have I mean we got Navy Yard, we got Capital One Arena. I feel like we should kind of hop around and showcase some of the
Absolutely.
sports sites around
Yeah,
DC.
you guys got some fun stuff going on with your you got, stadiums in DC are just you got RFK sitting there. Now you've got Leonis is trying to move. I think I said his
Yep.
name right. Move the Caps and the Wizards to Alexandria, and
Yeah.
folks seem really excited about that. Well, and it's fun. I lived in Alexandria for
Mhm.
like the first half of when I lived up there, and Potomac Yard, they were built trying to make that a thing. I don't see how all that's going to work and fit, and an arena and that amount of people going there. I, I don't get it,
I have no idea.
but yeah, we may need to dive into, 'cause it's been stadiums and paying for things, trying to get the state to pay, obviously, in taxes. That's been a big thing. So I think it could be something down the road. But
Yeah.
but paying for things is kind of what leads us, I think, to today. And folks, we are going to open the door of the NCAA and the NIL. And
And it
we
is
have mentioned it
something.
in a couple episodes, and I will preface this. This is part one. I don't know how many parts there will be. It depends on kind of how some of these lawsuits go, and then how other various rulings go, and different things involving schools and players and such and so forth. So this is part one. Um, and I think here, Liz, I want to, we need to lay a nice foundation for folks of what NIL is, some past cases
Hmm.
that NIL could have helped these athletes, I think, in the past, and now they're trying to use that to get some records back, some hardware back. But then the lawsuits that kind of led us to getting NIL legal, I guess technically speaking, and take it from there. So I guess I'll kick us off with just kind of letting everybody know what NIL is. So just in very simple terms, and this, from the NCAA, all their guidelines and stuff. So NIL, when we say that, that's name, image, and likeness of a student athlete. I'm not going to say name, image, and likeness every single time. So you're just going to hear NIL because that's so many words.
Yeah.
So NIL refers to the rights of college athletes to control and profit from their name, image, and likeness. Um, so before athletes did not have the rights to their own name, image, and likeness, and now they do, and that as of July 2021 when they approved it, and the NCAA approved it. So we'll say the NCAA approved the name, image, and likeness policy, allowing student athletes to monetize their NIL.
Hmm.
There are some state regulations in there. I don't really want to get into that because the NCAA has basically said, like, you don't have to necessarily worry about those. You won't get in trouble with the NCAA. So that's kind of in there. So essentially, it's open
Yeah, I
to
will just
everybody.
say that the state regulations, just to be clear, were expanding students'
Right.
ability to use NIL, not restricting it. And so, yeah, since the
Yeah.
NCAA had amended their rule, like Taylor is saying, it's kind of a moot point now
Yeah. Yeah.
because
For example, Alabama had instituted some NIL stuff in relation to that and in the law. But the NCAA's restrictions were looser, so they actually repealed their NIL
hmm
legislation. Which people, oh, they repealed? No, this was backed by Alabama and Auburn and all the top universities there because it was actually better for them and the student athletes. So if you see
yeah.
that, that's what that is. So what is an NIL deal? It is an agreement or arrangement between a student and a third party. Just that's very important. That is a
Hmm.
third party, such as a brand, company, or individual, where the student athlete receives compensation for the use of their name, image, and likeness. So as of right now, it's not schools. Schools cannot participate in that. This is just third parties that could do that. So I'll give you a few examples of various things that could be considered NIL, and this is for an existing NCAA student athlete. They can be paid for their autographs and memorabilia, camps and clinics, personal appearances, merchandise, affiliate or ambassador roles, NFTs, blogging, podcasting, public speaking, music, art, etc., social media, various things there. That is what they can be compensated for. So that's what it encompasses as of now.
Hmm.
I'll say this. Uh, Even though this is a new thing, um, athletes have been getting paid for years. I mean, it's not a secret. It's not
Yeah.
this thing. It's known. It's just you better make sure you don't get caught, right? You don't
Right.
pull the University of Tennessee and are handing McDonald's bags full of cash to players, right? Maybe not the smartest thing
Which
to
listeners,
do.
that's not a joke.
That's
If you
not a
didn't
joke.
know.
No, that's not a joke. You could look up Jeremy Pruitt and the dumb stuff he decided to do. Now, I'm a and I'm sure this is going to be unpopular for some folks. I'm a University of Kentucky fan. A lot of people
Ah!
have, yeah, 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 yeah,
Boo!
yeah, yeah,
Boo! Boo! Taylor,
yeah.
boo. Okay. I mean, I'm a Tigers fan, y'all, so.
Yeah, that's okay. I bleed the correct
If
shade of
anybody
blue.
knows about
So,
2008,
um, look, players play for coaches, not schools. That's the way it works in today's NCAA. So don't let's just get that straight. But so obviously that Cal just pays for his players and stuff, and there has probably been some stuff. I mean, but that is it's as we've talked about the NCAA being a business, the schools are a business too, and so yeah, there's some stuff going on now. Though there is some legal stuff that the schools can use, albeit not themselves doing it, right? But they can influence some of these third parties, and I think
mm-hmm.
that's a very that's what creates a bit of a slippery slope, and we will get into that. But that is what NIL is. It's simply being compensated for um, your own brand. That is you, right? Now, in the past, there have been some incidents where NIL popped up. The biggest one to me is Reggie Bush. Uh, he was a phenomenal. I don't like Liz. I don't know if you were watching, like college football in 2005. Um,
Somewhat with my
right,
dad.
right.
Like I said, but 2008, I think again, brokenhearted
Yeah,
Tigers fan. So
yeah, yeah,
but
yeah,
it's just
yeah. My 8 rings keep me happy at night.
you know what?
So
You could
in
stop that.
2000 in 2005, Reggie Bush was just an unbelievable player for USC, University of Southern California, and led his team to a national championship and won the Heisman that year, the highest award you can get as a college athlete, individual college athlete. However, he no longer has that trophy, and USC no longer has those wins. Those wins and numbers, they don't exist. They did not, as far as the NCAA is concerned, USC didn't play football in 2005. It got wiped away because they said that Reggie Bush received impermissible benefits. Now, in today's world, you could probably get away with some of this. So some of the stuff, $250 for limousine transportation that he received, round trip airfare for his stepfather, his mother, and younger brother to attend a game, a hotel stay in Las Vegas. Now, some of this you could argue is not. For example, um, some money to help Bush's family settle a pre existing debt, some money to purchase and modify a car,
Hmm.
weekly payments of $1,500. So that is when we get into the pay to play aspect that the NCAA does not like,
Yes.
right?
Which Taylor was very clear to make a distinction between that and the NIL stuff he listed earlier.
Right. So the NCAA said, nope, you received these benefits while at USC from these players and from these agents apparently. Now you could argue those agents were simply courting Reggie Bush, and they were. However, they were on campus, they were on the field at points, and they say that the running back coach Todd McNair knew about this. So that is why USC got in trouble. That
Mm-hmm.
they did not keep up the institutional standards of a school. That is why they got hit with losing scholarships. Couldn't play in a bowl game for 2 years, and honestly, they have not. And I will say again, we talked about this with the Michigan story. So that was the 2005 season. Championship was in 2006. That's just how it works. This wasn't settled until 2010. That's when they got the sanctions. So Reggie
Mm.
Bush was long gone. Reggie Bush was already he had already been drafted when this
Yeah.
story broke in the first place. And what's interesting is the story actually broke because the agents felt that they were owed money that they said the family would pay them after Reggie Bush was drafted in the NFL, and the agents cooperated with the NCAA in the investigation.
Oh, that's so shitty. I actually did not know that.
So yeah, I wanted to hold that one for you to see your live reaction to that because how shitty is that?
That's so shitty.
Yeah. And now they end up losing scholarships. Reggie Bush feels horrible about this because it ultimately hurt his school, right?
Mm-hmm.
Like, yes, it hurt him, and there was discussion of stripping of the award. He voluntarily gave up his Heisman Award, and trying to help in the lawsuit and stuff, or in the ruling from the NCAA. But
Kind
he
of what
did.
we were talking about with Harbaugh, some episodes ago about how sometimes the school or the athlete or the coach or whoever will go ahead and kind of almost punish themselves, be punitive toward themselves in the hopes that then the decision from the regulating body will be a little light. Would you say it's kind of like that? Like he was trying to like almost do like, I don't know, like here I'm punishing myself enough. Isn't this enough? You don't have to go any
Yeah, I think
further.
I think it's like and not wanting to be stripped of it, right? Like I'll
That true.
voluntarily give it up
It's like
and
quitting
stuff.
before you get fired.
Yeah, I think so. And
Yeah.
so and as well, uh, the school didn't have any associations with him because they were not allowed to. Now they have since ended their disassociation with Reggie Bush because they had a 10-year thing where they couldn't even be associated with one of their best players.
That's so insane to
It's
me.
it's very insane. So as of now, though, so then we get to June of 21, and the NIL uh, from the NCAA is allowed. So Reggie Bush says, "Hey, so all those records I had, that trophy I had, the
Mm-hmm.
fact that we went to a national championship game, I want that back
Mm-hmm.
because I wouldn't have gotten in trouble because of these NIL laws then." Now the NCAA said that no previous infractions would be reevaluated as the updated NIL rules contributed or continued to prohibit, quote, pay for play type arrangements.
Mm.
So they are saying that nope, we're not going to even reconsider it because these wouldn't even be permissible now. Now my argument would be there's a way to make those permissible
Yeah.
because the NIL rules are just they're too
Broad.
loose. They're too broad. They're way too broad.
Yeah.
The limousine ride, you could easily have that be a third party deal with a chauffeur company or whatever that you are going to do a meet and greet at, right?
Yep.
I mean,
Like
there's
we could basically say they could work with him if they wanted to.
yeah,
But my guess is the reason they don't is because they don't want to then open the floodgates to setting a precedent of sorts, even though it's not going like in court, right?
hmm
But a precedent in their regulating that can then have other athletes come back and say, hey, that thing with Reggie? What about me too? Because as we'll get into with the cases, they're already in major, major hot water with
Mm-hmm.
a ton of athletes.
Yeah.
And yeah.
So at this point, the USC and Reggie Bush are submitting a petition to the NCAA to get that 2010 decision looked at. They would like it looked at,
Mm-hmm.
and obviously, hopefully, reversed, right? Because
Mm-hmm.
you would like to, for example, USC has banners for all their Heisman winners. His isn't up there, and that sucks because you, it happened. The season happened. All
Yeah.
those games happened. He did all that
Yeah.
stuff. It's like, okay, I get on paper it didn't happen, but we all watched it. We all know what happened.
Yeah.
We know how good he was. And as well into that, Reggie Bush has also filed a defamation lawsuit against the NCAA. He's claiming that their use of the phrase pay to play, negatively impacted him and his reputation. That makes it seem like the only reason he went there was because of this, or the only reason I played hard was because I got the whatever. So that is currently ongoing, and he ultimately he wants his Heisman Trophy back.
Yeah.
And people are like, oh, it's just a trophy. That trophy, only one player a year gets that. I
Yeah.
mean, it is a hard award to win in the NCAA. I can't say it, and he wants it back. I think he should get it back personally, whether like the NIL thing or not. But I just think
Yeah,
he should.
it's just a very shitty situation. And as far as the defamation lawsuit, so for folks who don't know, defamation cases are not easy to win, especially if you are a public figure, because there is what is known as the actual malice standard that is then added to public figures. So it's not just about, can you prove that a lie was told about you intentionally and you suffered damages from that lie. You have to also prove as a public figure that there was actual malice, like a heightened level of just insidiousness behind the behavior. So that's like an additional layer of intent that you're having to prove, and it's not easy to do. That's why I know this isn't related to sports, like the Cardi B um, defamation lawsuit that she won recently. That's why that's such a big deal, because it's like, oh shit, like she was able to, win a big defamation suit. That's also why, not to like lean into uh, politics too much, but Alex Jones, that's also why that was such a big deal. Or Rudy Giuliani. I mean,
Oh
didn't he
yeah,
just, so yeah,
absolutely.
it's always really surprising when you see somebody prevail on a defamation lawsuit. So I wish the best for Reggie Bush.
Yeah,
I can't say legally that I see him getting, and I don't know if he has a very strong case, especially with the NIL piece, because the courts, they're pretty clear about not applying those things retroactively, right? they
yeah,
they typically are only proactive and only covering whoever is part of that group at the time of the filing of the complaint, and anybody going forward from
right.
when the rule of law is decided. So
Yeah, and another case where they have again they have petitioned to have some things brought back to him is Ohio State. The
mhm,
scandal that they had back in I believe this was where I got to get this right with Terrell Pryor and four other players back in, get this right here, in 2010. So actually,
mhm.
so interesting. The kind of the same year that they ruled on this Reggie Bush thing. It's known as Tattoo Gate. um,
Yeah.
so these guys, yeah, it's five players specifically that it's focused on. Apparently, there were 28 players over an 8-year span that this happened, but that they were selling memorabilia for tattoos, or trading memorabilia for tattoos,
Mhm.
which Ohio State still does not allow. They can't like jerseys and things that you wear associated with you. You're not allowed to do that today at Ohio State. They don't allow that, even though memorabilia is a thing that one can do. Ohio State doesn't like that. Um, and so they're petitioning as well, like, hey, like, we would have we could have worked out a deal. Again, it's going to be retroactive, it's going to be hard to
Mhm.
get. uh, the interesting thing about this one was these players were suspended the first 5 games of the next season,
Mm.
but they were allowed to play in the bowl game, in the Sugar Bowl, but then they weren't going to be able to play the next 5 games. NCAA said, well, what they got it didn't translate to anything on the field, but it was, they were gonna have to punish them for what they did it, but they didn't want to punish them for this game. I'm like, okay. Now their infraction ruling was not quite as hard as it was on USC. I
Mhm.
don't know if that's simply a dollar amount thing. What's interesting to me is USC was one player. They were also looking at the basketball program as well. But basically, you're talking about Reggie Bush, where this is multiple players. Um, so I don't quite understand that. But Ohio State's coach Jim Tressel resigned. He resigned over this. Like
That's wild.
I mean, he was suspended for 2 games, then 5. They basically said they were going to fire him. He said, "Look, I would like to retire so I can remain a Buckeye for life." And I mean, a coach lost his job over this, and then Terrell Pryor ended up not coming back to school to
Jeez.
face the 5 game suspension because they had said the locker room uh, was done with him because they felt Terrell Pryor was the reason their coach left. I mean, it turned into this whole thing where all of this right here in 2023 wouldn't you could make this not an issue at all.
Mhm.
They could figure out how to go get these guys tattoos, no problem. But like a guy lost it's just wild to me that not in the not too distant past there were all of these issues. Reggie Bush
Mhm.
there. We're going to get into another one, and that it was more serious and had a bigger impact. But if the NCAA had just figured this out years ago when they started making so much money off of these players,
Uh-huh.
wouldn't have these issues. I don't know.
Yep.
It's just like it's so hard for me to believe that it's taken this long to not even figure it out because we haven't figured it out at all. We're simply starting to figure it out.
Yeah.
But now we've gotten to this point and now it's a mess.
Yeah, and I mean, like you said, when the NCAA started making all this money, well, they don't want to admit that these players are profitable, right? They don't want to admit because that would go against amateurism and their whole
Ooh.
idea around that. So, what do you think? Should we dive into the cases?
Yeah, because I think everybody understands NIL. They understand why it's important. And now
Mm-hmm.
let's get into the meat of it because this is where this is a bit dense, but
Whew.
it is important, and again it lays that foundation for where we're at currently in NIL and the NCAA. So Liz, take it over.
So, let me go ahead and just state right now that the areas of law that are going to be covered in this include antitrust. It includes sex discrimination. It includes labor laws, and it includes um, federal rules of civil procedure. So we've got
Just on all fronts, my
all of it,
lord.
everything but criminal law, which you know what, I ain't got the energy for it after going through all this. So I'm glad we don't have any of that. But Lord Jesus. So let's start off with what Taylor's referenced a couple times in his stats and the facts when it comes to NIL, and that's the NCAA versus Alston Supreme Court case that was decided in 2021. Now, before I get into that one, and that one is the one that's kind of really started this whole domino effect of lawsuits, okay? But before we can get to Alston, we've got to talk about O'Bannon versus NCAA, and this was a Ninth Circuit decision decided in 2015. So this is not not a decision that was binding nationally. I don't know if I've explained this before in previous episodes, but it always bears repeating. When you hear me talk about, say, a Ninth Circuit decision, that means it is only binding on the Ninth Circuit. Um, it's not going to be binding nationwide. That is why you want to get to the Supreme Court and get a case that would be binding all over the country. Different circuits may find cases such as this persuasive and then want to adopt that same rule of law in their circuit. But again, it's not the rule of law anywhere but the Ninth Circuit. So in 2015, we've got O'Bannon versus NCAA, and this was Ed O'Bannon, who was a coach, right? So,
And
uh,
was a very Ed O'Bannon, great college basketball player. Won a national championship with UCLA in '95. Was the Final Four's MVP.
mm-hmm.
Didn't have a a great professional career, but not all college players do. And
Yeah, but he had a professional career.
yeah, absolutely. So yeah, he was. the name on this, along with obviously a larger group of
Mhm.
advocates on behalf of NCAA players.
Yes, and it makes sense about his own personal history with playing because he was obviously very passionate about this and it was all about protecting these players. And he filed this. Again, you heard me say it was decided by the Ninth Circuit in 2015, but he filed the complaint in 2009. So this was a long time coming. And interesting to know that he filed this a year before what happened with Ohio State. So, um, so this was in the works even at that time, and this was an antitrust case. How do I explain antitrust? I'm horrible at this, y'all. God, I should have gotten my friend who leaked on this episode because she loves it. Antitrust, however you want to say it. I always say anti, and I don't know why.
See, I say antitrust.
Antitrust probably is the
Sounds
classier way to say
more.
it.
I don't know.
I know. I will
Intense.
just say anti. I'll say antitrust, and it's basically saying you can't like affect healthy competition, right? Like in the economy,
No,
and
I think that's.
it's
I
like,
think no. I
is that
think.
a good way? Monopolies. You guys have probably heard monopolies. You probably played the game Monopoly, right?
Uh, yeah. I mean, I think that's. Yeah. Absolutely. I mean, what they're saying is, and again, it's weird because the NCAA is a nonprofit, even though it's not.
Mm-hmm.
But there is only currently one group, one thing that governs collegiate sports,
Yep.
which may change one day. There may be some conferences that want that to
Mm-hmm.
change, probably do want that to change, hope it does.
Yeah.
But currently there is only one. Now, you know, the NCAA is, I think, part would be like, well, there's only one government that
Because
does
I
the
I
law.
fully
But
believe
it's like,
fully believe the NCAA equates itself to a government at this point. Actually, a
oh,
monarchy. Let's be real.
I mean,
Like,
no, it's they believe that their position and is very integral and actually so important that they shouldn't even be messed with. They think they are that important, and in today's day and age, they're becoming less important to certain schools. So I think they need to be careful. But yeah, they
yeah.
don't believe that they, in my opinion, they don't seem to think they fall under the antitrust thing because they're a needed and necessary entity.
Right.
I would say.
And the problem is that they think about themselves. It's not even just about them being the single entity, and even though they're a nonprofit, the issue is that they are still affecting this competition in these third party situations, right? When it comes to these athletes, when we talk about NIL. And so this case was all about the restriction of compensation for NIL for specifically men's football and men's basketball. This goes back to Electronic Arts, better known as EA, and the Collegiate Licensing Company, aka CLC, who were co defendants in this case, and really centers around the appearance of current and former players who were in the EA Sports NCAA basketball and football games starting in 2003. And they were saying that, hey, our likeness, our images are being used in these video games and we're not getting any money for it.
By the
EA was
way,
smart.
you
Oh,
know what's fun?
what?
Reggie Bush was on the cover of NCAA Football 2007.
Shut up. That.
So he wins the Heisman, right? And then the next
Mm,
game that comes out features him on the cover. Yeah, but he's the one who got in trouble.
that is
So,
so shitty. Well, I mean,
yeah.
he would have been part of this uh, you know part
Yep.
of this class, so
Yep.
there's that. But that still doesn't fix him getting his Heisman and everything back, so he's still got to push those
No,
cases forward.
no,
but
no.
but vindicated somewhat
Mm-hmm.
because yeah, EA and CLC were smart enough to say, we're going to break off from this lawsuit and settle for $40 million. Cool, cool. All right. I don't know what happened with NCAA, whether they refused to settle or they couldn't come to an agreement, but they went forth with a trial and then appealed and, all of that. And there were appeals and stuff, went all the way to the Ninth Circuit. And the Ninth Circuit was like, yeah, sorry, NCAA, like this is totally an antitrust violation. Um, and you got to pay $42.2 million. And Then the
And they're
NCAA
saying
tried.
it's a violation because they're the only entity and they are specifically blocking these players from being compensated.
Exactly. They're
Okay,
specifically
cool.
blocking these players from being compensated. And then the NCAA decided to appeal to the Supreme Court, and the Supreme Court was like, "No, we're not granting cert. So whatever the Ninth Circuit said stands." And so that's what happened. And then we got nothing for a while because, like I said, this was
Well,
only
you
binding
want to
on.
know why we got nothing? Because they stopped making the games.
Oh yeah,
And let me
and this
tell
was
you
very
something.
narrow. This was
Let
very
me tell you
narrow and
something.
specific to the games.
That was a travesty because I don't for those who like playing Madden, whatever. NCAA football was one of my just like that's like a core childhood memory for me was playing those games. And man, I remember funny enough making a running back at Michigan and just dominating, won the Heisman like 4 years in a row. That game was so much fun, and because of this, like I'm happy for him. Ed O'Bannon did the right thing, but I'm also
Mm-hmm.
upset the games ended because the NCAA just said, "Well, we're not going to change our rules, so we're ending the deal with EA because they were so intense on not doing NIL
Yep.
that they straight up ended this game that I'm sure brought them a pretty good amount of money. But again, they didn't want to have
Hell
to.
yeah.
But then they wouldn't get to have that money. They'd have to pay that money because, God forbid, we pay some athletes some
For
compensation."
using their
Yep.
images in the games, because that's the thing, like these games would not exist without the athletes, and it's always going to center back to that. And I know I touched on this like um some episodes ago and just talking about how the athletes are the center of all of this, and it seems to be forgotten that student athlete is the center and core of anything
Mm-hmm.
regarding student athletes. um but nonetheless, they won. This gave us a ruling that you could kind of sink your teeth into for cases to come forward later. And so, like I said, there was nothing really happening for a while. No changes, no forced changes on NCAA because this was binding only in the Ninth Circuit. And it was very specific to the video games.
Mm-hmm.
Well, here comes NCAA versus Alston. This case was brought forward and relying a lot of on what O'Bannon set forth, and this was all about um, non-cash educated related compensation. This is all about, well, it's first of all, it's consolidation of two different cases into one, and this went all the way up to the Supreme Court. They did not address pay for play, but they did address the non-cash educated related compensation that Taylor was talking about earlier, and it was a 9-0 unanimous Supreme Court
It's
decision
a
that said
shutout. Good
just
God.
NCAA, you are wrong for this. Nope, can't do that. And our beer boy,
Can I please read this quote?
you could read it. Our beer boy, Justice Brett Kavanaugh.
I like beer.
What did Brett say? What did Brett say in the
Well, hey,
concurrence?
as I've been known for a while as the Memphis beer guy, so
Mm-hmm.
I guess we're weirdly related. I don't think I like that at all. Um, so Gorsuch authored the majority opinion in this,
Mm-hmm.
but Kavanaugh had just some strong feelings, so he also
Yeah.
wanted to make his thoughts known.
And I do want to point out for folks who don't know, a concurrence means that yes, he was with the majority, but he just wanted to say something extra. So just to point out, it was still that 9-0 unanimous. He just, like Taylor said, he just wanted to sprinkle a little something. So what do you sprinkle
Yeah.
on there,
So
Taylor?
so he attacked the nature of the NCAA's argument that athletes not being paid is a defining feature of college sports. Amateurism, right? Like, no,
Mm-hmm.
these are amateurs. They're not playing for money. They're playing for the love of the game and to better themselves. No, 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 no. He ain't about that. So he said, let's look at some other industries and how it's highly violative of antitrust laws. So here's a quote from him. Nowhere else in America can business get away with agreeing not to pay their workers a fair market rate on the theory that their product is defined by not paying their workers a fair market rate. The NCAA is not above the law. End quote.
Ooh. Ooh.
And when you
Okay.
put it like that, it's like, that's dumb as hell, NCAA. Like,
Mm-hmm.
no, no,
Yeah.
no, no, no. I go to work every day because I simply believe in
Working.
helping the American workforce. No, I work and I want to be compensated for that because I
S-
feel like I have value to what I do and I want to be paid. It's the same thing with the athletes. It's the exact
Yeah.
same thing.
And what Brett said was, I might like beer, but I also like money.
Oh, Brett.
Brett.
Brit. Oh, Brit.
But yeah, and in Kavanaugh's concurrence, he also just kind of really took a lot of jabs at NCAA and said, "Hey, anybody, everybody, this opens the door for us to maybe consider some other things that they're messing up on. And let me tell you that if we find that you've been messing up in other ways, we're gonna strike that down, NCAA." So he was given that little hint, basically saying, "Bring forth the lawsuits," and bring forth they did, y'all, because
Ooh.
we are in the midst of it. So I'm going to go ahead and set this up by saying all of these are pending. These are all currently pending, which is also part of why Taylor said there's going to be more than one part to this.
Yeah.
We're going to start with the NIL lawsuit that the NCAA says is going to break them, just kill them. They called it the death knell
Oh.
to their
Oh. Oh,
organization.
God. Oh, no. Oh. Oh.
So this was filed, funny enough, before the Supreme Court's decision was decided in 2021, but we could already see the motions going and everything going on that. And this is very important. Judge Claudia Wilkins, who's the U.S. District Judge behind the O'Bannon case and behind the Alston case, and we see that Alston case was already kind of moving up the chain, right? This was also filed in her jurisdiction and went before her. So very strategic attorneys, very strategic complaints, and that they are going right back to the source of where it all kicked off, because she is the reason that we are seeing these cases even come
So are
through.
they, they have this lawsuit. They get to pick where essentially they're like, hey, no, we're going there. Kind of how I guess how does that work exactly?
You
And
would ask me that damn question. So
I mean,
all of
I don't know. I'm curious.
let me hold on. Let me do a quick, and I should have looked this up before. Let me do a quick check and see where her jurisdiction is, because that
Because I've always seen that
will
with like
probably
various,
answer.
and not even I guess just like sports lawsuits.
Okay, it's because she's in the Northern District of California. So that makes
Okay,
sense.
okay,
Specifically the Northern District of California. So that's where she is in the Ninth Circuit. That makes
okay,
sense because of where a lot of stuff would be incorporated and a lot of. Okay, so that's why
okay.
California
Gotcha,
is a
gotcha.
very popular venue. We've also seen, like I said, the Ninth Circuit, which includes California, obviously, because it was gone through Judge Wilkins' court.
Okay.
Um, that makes sense. I'm not even going to go into the details from Civ Pro about how you get subject matter jurisdiction and venue and all that good stuff. I ain't even
That's
gonna
all
get
right.
into it. Just
Literally, you
know,
saying that sentence almost no. Let's. That's fine. That's
just know they got it. Just know they got it,
yeah.
and it's there. And they filed the complaint in that jurisdiction
Okay.
in June 15th, 2020. This is House versus NCAA. So this case is a class action lawsuit, and I will talk a little bit about civil procedure from this just to kind of explain class action lawsuits. So they are bringing the case. They're going for saying that this is all about striking the NIL prohibitions altogether. That's what they want. They want to strike the NCAA's NIL prohibitions. That, if I'm understanding correctly, would include pay for play. Um, they want to strike it all together and say, nah, none of it's good because it's all antitrust. And we've seen what O'Bannon started. We've seen what Alston started. We've seen how the Supreme Court decided. And we're like, no, 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 no. These are antitrust violations. All of the NCAA's NIL prohibitions should be stricken. And they wanted to bring a class action on that side. And funny enough, the NCAA did not contest either the injunction or the class certification for the issue of just simply striking the NIL prohibitions. Now, they still maintain that their prohibitions are lawful and should stand and all of that, but they they didn't contest it. They're like, yeah, let's go ahead and handle this in court. That's fine if it's like a class certification, whatever. And on September 2023, and this is just one part of the lawsuit, the other part is damages, but just on this, just on the idea of striking the NIL prohibitions, Judge Wilkin, she said, yeah, we can go ahead and have a class action for that. I'm going to certify the class. I'm going to go ahead and tell you guys now what it means when we're talking about certifying a class action lawsuit. So in the federal rules of civil procedure, and she specifically cited under 23 Rule 23b3, which states that the court finds that the questions of law or fact common to class members predominate over any questions affecting only individual members, and that a class action is superior to other available methods for fairly and efficiently adjudicating the controversy. Okay. There's other little rules and ticky things in there, and if you want to look it up, please feel free. Again, it's the Federal Rules of Civil Procedure, Rule 23. If you Google that, plenty of sources will come up, and you can read all about class actions there. It can be a little confusing, but that'll tell you what allows the court to certify a class. This is when they're saying that it is proper, instead of having everybody affected each bring individual lawsuits for the sake of fairness, for the sake of efficiency, for multiple reasons, it is a good idea to go ahead and allow a class action where all of these individuals can join into one lawsuit instead of everybody having to bring their own lawsuits. And that makes sense because the class that she certified includes at least 184,000 individuals among three different classes, split among three different classes. That's men's football and basketball, women's basketball, and one additional sports class pertaining to all D1 athletes who competed on or will compete on a team between June 15th, 2020 and the date of the judgment. June 15th, the reason that date is picked is that's the date, again, that the complaint was filed. So that's the starting point.
So the longer this goes on, the more
Yes.
athletes it's going to encompass.
Exactly. So that's why it says at
Ooh.
least 184,000 individuals. And so that makes sense because why they say, why would we allow 100? No, we're not going to flood the courts with 184,000 individual lawsuits. And also that isn't fair because again, there's that sense of fairness. That's not fair to the individuals because that's a lot of money rather than being able to come together and pull their resources together for one attorney for their class, like, and those
Right.
attorneys fees. So NCAA said, fine, we're not really gonna, they didn't contest either the injunction that the plaintiffs asked for. Injunction meaning they're saying, hey, until this is decided, the NIL regulations, prohibitions need to not be enforced. And also just the class certification itself. Here's where the NCAA got real upset though. So remember I said that's just one part of the lawsuit and the other part is damages. I want to remind everybody that when we say damages in law, it means money. Whenever you hear the word damages, think money. That's what that means. In November, so that was in September. In November, and this is all this year. I don't know if I was clear. That was September 2023, so November 2023. Judge Wilkin said, you know what? I'm going to certify the classes for the damages too. Yep, that $1.4 billion. And oh, by the way, if the plaintiffs prevail in an antitrust case, they get 3 times those damages. They're going to get $4 billion if they win this trial. And that's when the NCAA said, "Ah, shit, that's going to be the death knell to our organization. You can't do this." And that's when they asked for an interlocutory appeal, which means they are asking for the class certification, whether that's proper, to be decided before the trial, before the merits of the case. Usually you can only appeal, once a decision is made, right?
Mm-hmm.
Like just
Right,
just
right,
just
right.
just to talk about it plainly, you appeal something once a decision is made, once the trial decision is made. They're saying, no, 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 no. We need to go ahead and appeal this class certification specifically for the damages right the hell now because we can't take this risk. Even though they said this, even though we think our argument is strong, we can't take this risk because that will kill our organization. That's a lot of money if you let all of these people, rather than bringing individual lawsuits. And oh, by the way, you should let them bring individual lawsuits anyways because, this isn't fair. because there's some athletes in there who could get a ton of NIL money, and there's other athletes who might not get any. And it's not fair that every single one of them gets to join. That doesn't make any sense. That's not fair to us. But then the attorneys for the plaintiffs, for the student athletes, said, but that's how it works whenever we allow collective bargaining and unionizing when it comes to professional athletes. That's what happens. When you have a professional athlete who is the star player on a team, doesn't matter. Whenever they come together as a union, when they come to the table with a collective bargaining agreement, that benefits every single player who's in that group. It's not just going to be for the Shaquille O'Neals. It's not just going to be for the Kobe's, rest in peace. It's not just going to be for the Michael Jordans. It's not just going to be for the, Steph Curry's, for the LeBron Jameses. It's going to be for everybody.
Mm-hmm.
And if it weren't for these NIL restrictions and the bullshit that the NCAA put student athletes through, they would be doing the exact same thing as the professional athletes, and it would lead to the same result. So, as far as I can tell, there hasn't been a decision yet made on the interlocutory appeal on this. But the NCAA, they're scrambling.
Yeah. Well, and I'll say so. Obviously, 2022 is the last numbers we have as far as because they have to say all their financial. They're nonprofits, so they're open with all their finances. So their revenue of 2022 was $1.14 billion. Their net assets, they're saying, is $457 million. So, as far as I can tell, 4 billion is more than that.
Yep.
So
And I want to.
I guess they're right in that yeah, we can't afford that. So,
yeah, they can't afford it. They're saying it's going to kill them, and so this
yeah.
is such a big case that folks should pay attention to. Because here's the thing, and here's the other argument. They're saying, okay, but here's the deal. You just having this in place as a class action and knowing that the potential award is that high means that if we want to settle the case, we still have to settle for a ridiculous amount of money that's going to hurt us, because the plaintiffs know that their potential is going to be that. So even if we settle, hey courts, you're still killing us over here.
Mm-hmm.
Do I think that they're going to prevail? I don't think so. I don't see a court saying, yeah, no, this shouldn't be a class action. I mean, and again, I encourage listeners, if you want to look up FRCP Rule 23, from what I can tell, this falls under that. And let's not forget that Judge Wilkin, this district judge, she's had 2 cases where that have been appealed, that her decision has successfully been upheld, one of which at the Supreme Court. Like, she is not a stranger to these NCAA lawsuits.
It seems to have pretty good understanding of how the NCAA works and all the fair. I mean, I wonder how much she has read about. She has to be one of the foremost experts, right, on this subject, and so
gotta be.
I think that's hard for the NCAA to argue, because clearly the Supreme Court, who, I mean 9-0. I mean, all of them agreed on this, which is. I mean, there can't be that many 9-0, decisions. I mean, that's strong.
It's very strong. No, there's not a ton of unanimous. Like, that is very strong.
Yeah.
Kavanaugh's reproach of the NCAA is very persuasive, obviously. These are not the only and by the way, what I'm listening to is not even all of the lawsuits that are in process. These are just like the main ones that I want to highlight, and they're also hitting different areas of the law. I've got 2 more I'll discuss after this, but before, I want to go back to the fact that while we're waiting on this to see what happens with, the potential striking of the NIL prohibitions on the NCAA, we now have it, thanks to the Supreme Court, that student athletes can profit through non-cash educated related compensation. And Taylor, I wonder what could possibly, since we have that broad list, can you think of just like the wildest thing that could constitute an educated related expense that a student athlete could profit off of?
Cash, and so
not cash,
as long as it's not literal money. Well, I tell you, I actually know, um, because I know some folks that up in Columbus, Ohio, um, a local car dealership up there um, gave multiple athletes, uh, well, one of them, he got a truck that had, oh, it was like a Ford F-150 with like 600 horsepower in it. So I assume that it was like, hey, man, you know, if you're going to be doing this internship, you need to be able to get there as fast as you can because you want to learn, and so we're going to just give you this ridiculous truck uh, to for, but it's not cash, so you can have
It's
it.
not cash, and it's education related because
It's
you're going to get
educational
to your
because
internship. You're going
you're
to get to
going to your
school.
internship. Yeah, you're going to drive it to school.
Yeah. Could you imagine, especially like during COVID? Man, education related expense. Got to put them in this mansion because got to quarantine them together,
Yeah,
right? Got to
yeah,
keep them
yeah.
healthy and
Just
safe
so we're
and
keeping the circle small. Also, since they're going to be
circle
attending
small.
virtual classes, but there's going to be a lot of them in a room, so we're going to put in a projector system. Um,
Yeah.
some would call it a home theater system, but they're going to be
Yeah.
able to do their Zoom classes.
And it's got to be huge so they could sit 6 feet apart,
Yeah, so it's going to look
like
kind of like a movie theater inside this home.
a little bit.
Um, but again, there's multiple of them, so we're gonna have a couple roses, and they're gonna be covered because we're very aware of how sitting obviously can be,
Mhm.
so we're gonna just so they're attentive, right? They're gonna be very comfortable seats.
Mhm.
I mean, yeah, I mean, where does it end? Where do
Where does it
you
end?
say they can't have that? I mean,
Yeah.
I don't. Um,
At this point, just give them the cash. Like, go
just
ahead and
go.
strike the prohibitions
Hey,
and give them the
hey,
cash.
justice for Jeremy Pruitt. I should be just let me give him a McDonald's bag full of cash. I
Just
mean,
give them the McDonald's bag full of cash. I'm just
yeah,
saying it's better than what they were doing at the McDonald's in Chicago back in the 80s. Weren't they handing out like drugs through through the drive-through? Is that like a famous scandal? So you know what I say? McDonald's bag full of cash is just fine.
it'd be fine with me too. I'm totally,
I mean,
I'd be
it's
good
just
with it.
they
Yeah.
make these people so much money, and they, in my opinion, work for them. And this brings us to the next case, which
Mhm.
I find extremely interesting. And I got to tell you, I didn't think about it at first, but I was like, damn, that's creative as hell. So we were talking about interlocutory appeals and how those are rarely granted. Here's a case where it has been granted. This is Johnson versus NCAA. Again, this is currently in process right now. Came about in 2022. This is a FALSA case, y'all. That is the Fair Labor Standards Act. That is the case that sets the statute that sets minimum wage, that sets safe working conditions, all kinds of stuff, right? Overtime pay, what's an exempt versus a non-exempt worker, all of that. In Johnson versus NCAA, the Dartmouth men's basketball players said, you know what? Under FALSA, we're employees. All athletes are because we're working for the school.
Fucking Dartmouth, they're
Those smart ass
smart.
kids.
Oh yeah.
And they said, we're working for the school. We work for them. We are employees and we are entitled to not only minimum wage, at least for our time we spend as student athletes working for the school, but also workers' rights and protections in their workplace that can increase their safety, their well-being, make sure they have breaks, make sure they have
I
like
mean,
it.
they have a schedule. They have a
They have a
uniform.
schedule. Uh
Um,
huh.
they have
They have to
goals.
schedule their classes around
They
what
have
they do.
they have goals that they're required to meet
Mm-hmm. Mm-hmm.
to stay on the team to
To
keep their
stay on the
employment.
team,
I
keep their
mean,
employment.
yeah, okay.
And it's interesting. And Judge Padova is the district court judge who said, "All right, I'll let it go forward. I don't think we're not going to grant a motion to dismiss. I think they got standing, and I think they
So you're
have
just
a
like, no, 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 no. Let's see what he can do. It's just
yeah,
kind
yeah,
of that,
yeah."
like, let him
He's like,
go,
no.
let him go.
He's like,
This is
he's like,
interesting.
no. But this cocky motherfucker, let me tell you, I'm laughing at this judge. So first of all, he said the NCAA's got circular logic. He laid into them. And I love what he said. He said, you're classifying athletes as amateurs and then denying them pay because they're amateurs. It's circular. You're it,
So
I'm
very
so, you
very
know,
similar to Kavanaugh. I mean, so
very similar to Kavanaugh.
he's kind of saying that as well
Is
of
Judge
hey,
Padova a man? Let me check. I want to make sure I'm not misgendering Judge Padova because I didn't even think to check. Yes, John R. Padova. So yes, he. Uh, dude, he's 88 years old. Damn, he's been around a minute.
okay.
He was born in 1935. Good lord. Okay, but he's a senior United States District Judge of the United States District Court for the Eastern District of Pennsylvania. So this is going to fall into the Third Circuit. So remember what I said, guys, about jurisdiction. So Third Circuit. This cocky dude said, "You know what? You know what, guys? I don't think that the NCAA should have. We shouldn't grant a motion to dismiss. I think the plaintiffs have stated a proper claim, and I think they got standing. But you know what? I'll humor you. I'll grant you that interlocutory appeal so that they can decide at the appeals court about the motion to dismiss. Have them question my logic. They could absolutely say. And then the Third Circuit said, nah, no motion to dismiss. So it's still moving forward. We're
Okay.
waiting. We're waiting to hear a decision. But I first of all, the absolute audacity of the Dartmouth men's basketball team to not just go, hey, we should be paid for a name, image, and likeness, or hey, we should be able to. They were like, nah, fuck it, we are employees of Dartmouth. Like, I just
Yeah.
find that so creative, and I
No,
just
that's it's an interesting because there is in some of the research there is now a college football players association.
mm-hmm.
There aren't players. Obviously, the NBA, NBAPA, NFLPA, each of the big four, like they have their player association that right does their collective bargaining agreements, negotiates all that. It's a mixture of lawmakers and players that are on the board, all that kind of stuff. But it does not exist in college because, again, they're amateurs. They don't need
Yeah,
people to
amateurism.
argue amateurism to argue on their behalf. And yeah, Dartmouth saying like, no, we should have I believe they were the ones talking about having a union basically, right, and basically creating this players association that will handle all of this stuff for us and bargain on our behalf and get our
Mm-hmm.
contracts. Yeah, outside of NIL, like no, like we should be paid by the school just like Dave the history teacher gets paid. I mean, that's an interesting.
Yeah,
I do like it. I like
I
it.
like it. I think it's really creative and interesting,
Yeah.
and also, I mean, the NCAA, like I said, they're they are really trying to hold on to what they have. But yeah, the whole idea of them being employees, that was just really, really creative to me.
Mm-hmm.
And I thought, I don't know. I just really thought that was like a really good route to go in. I just think hit them from all sides, right? Like, yeah, maybe it won't prevail. Um, you know, and the appeals court even said like they don't buy the NCAA's argument. So it's at least worth hearing. But
Yeah.
even if naysayers say, you know what, they're not going to make it work, it's not going to happen. I say hit them from all sides. There is no benefit in not trying. And I do find this to be an incredibly, incredibly unique route to get
Yeah.
there. And then here's the funny thing. So going back to the case that is before Judge Wilkin right now, this case about the class action lawsuit. What I find interesting is how the NCAA is constantly almost shooting itself. Well, not almost. It is shooting itself in the foot. It is absolutely shooting itself in the foot. It They said, "Hey, you know what? Here's something to think about with letting them in this class. Uh, you know, it doesn't make sense again to have them all come at us for this big amount of money when not all of the student athletes make that much money from NIL. It's just not. It just doesn't make any sense because, well, haven't you seen women athletes? The female student athletes, I don't know if you know this, but there's a huge, huge disparate result in how they're like, they don't make nearly as much money as the men. They don't make nearly as much money as the men. And then somebody said, "Oh yeah, you're right. Bet." And then after that, on December 4th, there was a lawsuit filed under Title IX saying,
but Liz.
say, but wait, there was a lawsuit filed on Title IX saying that that the support athletes receive for NIL activities like education to help with social media promotion falls under the requirement that athletic departments provide equitable publicity between men's and women's athletes. And they said, you know what, NCAA, you are so right that we have a disparate impact on us as women and we're not getting paid enough. And that is directly a result from how your organization and the schools don't
Hey.
promote us.
No, listen, listen. As a board member of the NCAA, listen. We've tried to get these people to watch these women play. They just don't want to. You know, it's just they're one, they're women. You know, two, it's they're not as good. Three, I mean, hey, they are nice to look at. Like, no, it's the dumbest thing. It's the, how are you going to say that like out loud? Like, also, here's my thing: if they were arguing, if they were like, oh, hey, these people shouldn't be together, like, what did they think? It's like, what did you think that was gonna get you? Okay, it's gonna cut out what? It's maybe half of the people in the lawsuit. You're still screwed, even if they were gone. So I don't know how you benefited from that anyway. All you did was open yourself up. Like that's what they said. They sound like that. That like that
Yeah.
character of just like, oh yeah, women's sports. Like dude, you're the problem.
Yeah, and so
You're the
they're saying,
problem.
and so the female athletes are saying, well, you know, and by the way, I do want to point out that this is specifically coming from 32 University of Oregon athletes at the club and varsity level, and it is specifically beach volleyball and club women's rowing. And they're making the accusations of inequity. And they said, well, Oregon gives its male student athletes much greater NIL related training opportunities and income than its female student athletes. And this falls under Title IX, which, for those who don't know, Title IX is a federal law that prohibits sex based discrimination in schools that receive federal funding. So that's, you know,
And
all, if not all, but like very very much most colleges and universities, right? So
yeah,
so yeah, that I just love that the NCAA was like, well, you know what, you guys shouldn't be able to sue us under a class action for NIL because if you haven't noticed, the women athletes don't make that much money. And then the women athletes were like, oh, thank you for another claim that we can
and
go
and
forth with in a
yeah,
lawsuit.
and not that they can't. So like Angel Reese, right, very
Oh
one
yeah.
of the most well known players in the country as far as women's basketball goes for LSU. Her NIL is estimated somewhere around $1.3 million. Um, Now, yeah, people are like, oh, well, see, look, she's the one getting paid. That is so. She is the top 1% of the 1%. That is incredibly lucky she's gotten that. It
Yeah.
is. It's the sports like beach volleyball,
Yeah.
rowing, field hockey, and all these schools. And we're talking about University of Oregon, which is in a major conference, moving to the Big Ten. Right? They are a big school. What about a school like Kent State? What about a school like Rice? I mean, they're even their men's basketball players aren't going to be making as much, and definitely not the women's basketball players. So
Yeah.
that is, I think, again, yes, there are women athletes, Cavender twins, that they're like a really famous one, have done very well NIL, uh, but it's rare. It's not common. So I think it is important. It sheds light not only on the smaller sports at larger schools not getting that equal benefit, but the women as well. And so, yeah, like you said, hit them from all sides and create all of that discussion. Because I think
Yeah.
the more discussion that we can have on this, I think the better impact and better change we will see from it. Um,
And the crazy thing is, like, listen to this, okay? I want people to think of these numbers because here's the thing that gets me. I'm gonna go ahead and hedge off any goofy men, okay, who say like, "Oh, but women athletes, they don't make as much." And all this. Women are target consumers. Women are the ones who drive dollars. It's not men. And I say this as a content creator. 74% of my following, women. That makes me so profitable to tons of brands because they don't sounds I'm just stating the facts of how the industry works, right? Just in content creation alone. They don't want follow content creators who have mostly male audience because women drive the
Let's
dollars. So
let's
let's talk about it. So let's see, how much is American sports worth, okay?
okay.
So this is the most recent thing I can find. The North American, so not even just the United States,
Sure. Okay.
sports market has a value of about 71 billion US dollars.
Okay.
That includes men's and women's sports,
Yeah.
okay? That's
Yeah.
not just men's.
Yeah.
The wedding industry alone is about 50 billion, and that is women, right? If you want to look at that plus the makeup industry, right? Plus which by the way is like 500 billion dollars,
Oh,
just
it's something
just makeup.
stupid. Yeah. Oh
Stupid,
God,
stupid
stupid,
amounts.
stupid.
The fashion industry, all of these things, right, that are driven by female consumers. And so I'm not saying that that means that making an argument that women are more deserving of something or anything like that. I'm just saying we're at least deserving of the same equal
Um.
consideration because while yes, you're looking at male athletes and you're looking at that market, let's look at what Angel Reese is doing. She's gonna bring in things like when it comes to endorsing makeup, fashion, things that you're not typically going to see with male athletes. And I feel like that's been a very overlooked concept of like there's a market for men that have found their niche, right? But there's this whole unexplored side of what female athletes could push and sell and like put their faces on and really brands that they could tie
Yeah.
themselves to. And I feel like because there's been men at the helm of all of this and trying to also use women as scapegoats to just not just deny women NIL rights but men as a whole. Like they're trying to do that because if they break the class, they break the class. That doesn't mean women get booted out the class. That means the whole class is
Mm,
destroyed, and even the men in the class would have to
mm,
each bring individual lawsuits. So they're trying to use women
gotcha.
as like
Okay.
a low man on the totem pole, so to speak, to then break everybody down. So that's what's going on there. But I feel like there's this like hyper focus on what sports are supposed to be, and it is through a male lens, that they're really actually undercutting themselves because they can make so much more money if they really harness the power of their female athletes and
Well,
what those
and
athletes could tie themselves to. I don't want to see LeBron James partnering with Sephora, but I for damn sure would love to see. You know what I'm saying? Like female, I want to see.
well,
I want to see Serena
if you need
Williams.
to if you need to
So,
understand how important females are to sports, and everyone is so tired of it, and you know why you're tired of it because it works. Taylor Swift and the
yeah,
NFL, that
yeah.
has completely the NFL that already makes insane amount of money, right? Is the most
Mm-hmm.
popular sport, have now opened up a whole segment of fans that they did not have access to,
Yeah.
right? And it's like people can, and yeah, I get somewhat frustrated too, but at the same time, you're opening your sport to a whole new fan base who, you know, couldn't have given two shits about what the Kansas City Chiefs were doing, right? But
Right.
now very much do, or whatever team. If like they live in whatever city, and they're like, hey, let's, hey, if Taylor Swift likes it, it goes, goes and their boyfriend sitting on the couch every Sunday, sits down with them, starts watching.
Oh
Then they buy a
snap!
shirt. I mean, they're that opens up so, and we're just talking about a celebrity doing with that. Now you're getting into athletes. That's a whole new thing.
Have you heard about the Seattle Krakens, the
I
hockey
mean,
team?
Uh,
Like what
I'm
happened?
I'm gonna correct you. It's just Kraken. There's
Oh,
no S
Seattle
on it.
Kraken. I'm
There,
sorry. I'm
it's just
sorry.
Kraken is a thing. I'm
My bad.
aware of the team. I
Have you
uh
heard hashtag crack my back?
uh I no, and I didn't expect you to hear. No, I of the things
so
on my bingo card that wasn't on there.
so just speaking of women and the power that they have, some women on Book Talk, which if y'all don't know is the book obsessed side of TikTok that is mostly women
Okay.
found a hot male hockey player on the Seattle Kraken and just like went fully in and said that he was like what they pictured with a certain romance novel that involved a woman falling in love with a hockey player. And when I tell you that the women on Book Talk made the Kraken sales and the attention and all that just skyrocket, it was wild to the point
Okay.
that the
Okay.
team started partnering with the book doctors. Now, there was some drama that ensued because allegedly the main book talker who started all of this crossed some boundaries and made the guy and his wife feel uncomfortable, the player and all that. So there's some
He
iffy
did
things that
he
happen there.
did call on fans to stop sexually
He
harassing
did
him.
call on fans. He
And
was like, y'all got to stop.
I will say
But,
this: this is Alexander Wenberg is the player.
mhm,
He's an attractive man.
yes,
I will say that he is definitely
he is.
attractive. Yeah.
And I fully do not support any of the harassment that came his way, and I apologize to him and his wife that he had to experience that. But I had found this story like way after all the stuff had happened. I do want
But
to point out
proves
that I did not engage in the book talk craziness,
but no
but
but proves how but
proves the
proves
point.
females are an integral part to this. And yes, those are
Yes.
professional sports, and yes, we're talking about NCAA. But
Yeah.
the earlier, right, the earlier you can start it, the easier it is. Angel Reese, Caitlin
Mm-hmm.
Clark, right? These college basketball
Mm-hmm.
players, right? Much closer in age to an 8, 9, 10 year old girl who is wanting to play basketball and sees that. And I mean, you think about the influence, right? And hopefully it's positive influence that they could have
Mm-hmm.
on that. Uh, it's a huge untapped potential that it is becoming more in sports. There is more happening with it.
Mm-hmm.
Hopefully it continues to grow. And again, because at the end of the day, uh, it's helping everybody. Like, hey man, like
Yeah.
if you're good at what you do, yeah, make a bunch of money. I'm
Like,
full. Go ahead.
remember when like there was a whole trend of the focus on fashion of a bunch of the male basketball players? Like they were just super into like,
Dude,
and it was just like, and
every
it became a
Sunday,
thing.
every Sunday,
Yeah.
it's NFL. It's the one today from the NFL was like fits hotter than the action on the field. And
Yeah.
it's just 10 photos of players walking into games with what they're
And
wearing.
I'm going to tell you, if they had harnessed that energy with women athletes a long time ago, I'm just going to say like they're really maybe if the NCAA knew how to play the game better, they wouldn't be hurting so bad and scared that a $4 billion lawsuit was going to, shut them down. I don't know. All I'm saying is the sexism is hurting everybody, right? And just everybody's got something that they can
Yep.
contribute to this. And so, but again, I just find it even more hilarious that they're shooting themselves in the foot by trying to go after women, and all they did was give women a claim to go, oh yeah, good point. Let's talk about Title IX then. So that's my summary of the main lawsuits. And all of those that I listed, aside from the Supreme Court case that's kicked it off Alston, they're ongoing.
Yep.
So we'll see what happens, and of course, we'll give updates as we go. I want all the athletes. The student athletes as a whole, men, women, non-binary, whatever. I want everybody to just get what they're owed because, again, I think it's really messed up that they are the center of this. They're the reason why all these people have money, and they're not getting the
Right.
money themselves. Like it's been a long time coming. And I
Yeah.
do hope the best. I'm just not sure from a legal standpoint how successful Reggie Bush will be, but I want him to be successful.
Right.
I hope that my cynicism is proven wrong and he
Yeah.
prevails in his
You know,
suit.
I
So
I just want for I understand that Kentucky men's basketball players are going to get well taken care of. The Alabama football
yeah,
team, they're going to take care of. But the dude who is on the track team at some D2 school, like, hey man, let's get him a little bit of, because obviously he can't work a job because or she, right? They can't work a job. Get a little bit of money so they can take their person out to dinner or go buy something, go buy a new pair of Jordan, whatever. Like, be able to offer those student athletes the same opportunity for folks who can't get in. So
exactly. Let them go dude, and like I said before, content creation has changed the game. It is a great equalizer because somebody from a D2 school who nobody's ever heard of and maybe will never go pro could become an amazing influencer and content creator if they were allowed the chance and it wasn't, a violation for them to do so as a student athlete. Like, we see it all the time. Maybe they have something else to contribute. And
Yep.
that is another part of it too, is like when you're not allowing them to go out and go further and kind of venture out. We know so few of these. We've talked about these statistics before, how few of these students will actually go on to be pros, right? We're just hampering them. And I said it before in another episode, the student part of student athlete is the most important part of that phrase. They are students. They are trying to figure out their way forward, their path forward, their career, the rest of their lives. And this can have such an impact. And so if this, if these NIL opportunities can help a student who maybe won't go pro, but could totally swing into like marketing, something like that, advertising, maybe shift gears. If some of these student athletes, men and women, because I've seen many who are very attractive, maybe they want to go walk in New York Fashion Week, maybe they want to be models, after they're done with their, I want them to be able to harness the power of their images and the power of their names and their likenesses and all of those things so that they can make a way for themselves in this world. It's already tough. The economy isn't treating anybody real well. Everybody's kind of struggling, and I just want them to be able to make their way. Poor kids. I know what it's like to be a broke ass college student.
Yeah.
But all that being said, Taylor, this was a good episode, and we're switching things around.
Yeah,
time.
Since you were like, I have a pop culture for you, I'm like, well, I got one for you.
Ha ha!
All right, so okay. We've talked a lot about Reggie Bush in this episode. Do you remember what year he won the Heisman? We did say it in this episode. Do you remember what year that was?
Was it 2011?
No. That's when the sanctions came down. He was long gone from USC.
Oh, so it's 2005.
2005, yes. So
okay.
So the 2000.
I got mixed up.
Yeah, 2005. And so in that year, obviously, album CD sales were still, I think people were still buying CDs at the time back in 2005. And I'm going to let you can, let's see if you can name me the best selling album of 2005.
College Dropout by Kanye West?
No, it's not that.
That was my guess.
It would be The Emancipation of Mimi by Mariah Carey.
It sure the hell was. Why do I feel like they came out? I didn't even notice they came out the same year. Because didn't College Dropout come out that year?
I have no idea.
And that's why I said that, because I thought College Dropout came out that year, but
now
if it was the best selling.
Now, the second best selling album out of the year, if you want to take a guess.
Oh, that was 2004. My bad. Okay.
Oh, how dare you, right? Do you know what the second best selling album was?
If it was Emancipation of Mimi, Confessions didn't come out that year, did it?
I don't believe so.
That was earlier. Shit, it all runs together for me. If it was Emancipation, hold on, Emancipation.
I'll give you a hint if you'd like one. It is a female singer.
Oh. Okay. Damn. There's a lot. There's a lot in my head for 2005. I'm thinking back, like, what was happening in 2005? I was 15. 10th grade. I definitely played a lot of Gotta Shake It Off from Emancipation of Mimi album.
The band, your next hint
is it Paramore?
It's not Paramore. A Day to Remember covered one of this singer's songs.
Oh, God. The band A Day to Remember covered one of the singer's songs? Mm-hmm. I know, like,
if you want one more clue, I'll give you the big clue.
Okay, what's the big clue?
This person won American Idol.
Kelly Clarkson?
Breakaway by Kelly Clarkson was the second best-selling album.
Why did I think she won American Idol like way before?
Well, it was before. She did win that before. I believe 2002, 2003 is when she...
That's what I was going to say. Okay, but her album didn't... But that album... but the Breakaway album didn't come out to 2005.
Right. All right, now...
Kelly sure can sing, too.
Now, she was... Okay, so, to tie it back into sports...
Okay.
She was offered a scholarship to university. She chose not to go. She decided to go after music, but she was offered a scholarship to a university. And that university was the team that played Reggie Bush's USC Trojans in the 2006 National Championship Rose Bowl.
Oh, I ain't gonna know
It
this.
was again, childhood memories, one of the best football games I have ever watched. Do you know the team? Your hint is
Was it
uh
Kentucky?
no, we're not too good at football. We're trying though. We're going to be good next year. I believe. I'm going to believe now.
Eh,
The quarterback of this team was Vince Young.
that does nothing
Doesn't
for me.
help. Doesn't help.
No, you're just gonna tell me because I'm never gonna get it. I can guess
All
another
right.
team randomly if you want.
All my just throw it out. Let's see if you do, I'll go nuts.
Ole Miss.
No, you're wrong. That would have been cool. Maybe I can edit it. For all my sports folks out there who remember this game, it is the University of Texas Longhorns. Vince Young, 4th and 5 from the 9, runs it in for the game-winning touchdown, also gets the 2-point conversion. They win 41-38. And honestly, one of the best. Let me tell you how much I love this game. I whatever bought or downloaded the game on iTunes so I could put it on my iPod so I could watch it. Because I loved it. Vince Young was my dude. He got drafted by the Titans. I was so about it. I love playing, again, NCAA football, playing with Vince Young, running the option. It was a
Do,
vibe. It was a vibe, Liz.
hey,
It was a vibe.
speaking, I love that. First of all, I love your happy memory, but you
Yeah.
just reminded me of a memory that's completely unrelated. But do you know that Catherine and I did not have iPods?
I know she didn't, so you didn't as well.
We had
You
Zunes.
had Zunes. Yeah. You had Zunes.
We've been we've been outliers for a while.
She is very protective of her Zune. And if
Yeah,
I mean very,
yeah, yeah. And my Zune got lost in her car. One of mine did, and we found it 2 years later. Her car was like a black hole.
oh wow.
Yeah, we looked and looked and looked, and then didn't find it. And then one day it just showed up. We were like, "Damn."
There it is. There it
Yeah,
is.
but I don't have my Zune anymore. I think I gave that one away to one of my nieces, and then like I don't know, it wasn't that long after that like you could get music in your phone,
Right,
so
yeah.
I just like started
The
doing that.
long
But
lost iPods, Zune. Man, good
hmm
times, man. Good times.
yeah, good
Um
times.
well, I know this was a dense episode, folks, but
A long one, but
it's a dense topic, and and I feel God, I feel like we barely really even got into
oh, there's more lawsuits. I
what
just kind of
NIL
covered.
is. And I mean,
Yeah,
I would, because I would love to go through like some of the crazy NIL deals. That
yeah,
one of my favorites is the coldest to ever do it, Thompson. His
yeah,
Yeah, signed with like the HVAC company. Like that's it's wild stuff like that. And so we'll get into it down the road. We'll probably we'll
yeah.
see what some of these lawsuits happen. Um, I've got a couple ideas, I think, for some stuff we could talk about. It's definitely going to be interesting. But again, if anybody wants to hear anything specific, if you have an idea, comment, hit us up on Instagram. I'm the Bespoke Taylor. That she is Booker Squared. Let us know. If you're watching on YouTube, comment there. Spotify, you can leave us a little message too. I just get to see. It's not public. It's just for me. So if you got something for me, I'll take a
It's
look
just
at
for
it. It's just for
Tyler.
me.
It's just a little something, just a
Yeah.
little, a little, a little, a little, a little
Yeah.
nice thing.
But shout out to one of our big fans who listens on Spotify. He sends a couple nice messages. So
Oh,
shout out to him. Yeah, but no, I like I said, this was great. I enjoyed it. I'm glad I got to hit you with little pop culture, but I fully expect you to be on top of your game
all right,
and have something for me next week. Okay.
all right, all right. All
Lord.
right, thanks everybody, and see you next time.
Bye bye.
Bye.